La Cour! Please be seated.
Reproductive technology gave her hope, but the law gave her heartbreak. Today, let's look into a landmark case which stretched the understanding of reproductive autonomy almost to its breaking point in Europe. Evans against the United Kingdom. By the end of this video, you will get a fresh taste of how international and common law courts frame disputes and reason, and how experienced lawyers and legal teams structure arguments to advocate for their clients. Around the early 2000s, Natalie Evans was in her early 30s and living in England. She and her fiancé, Johnston, had been trying to have a baby naturally, but when that failed, they turned to IVF. Then everything changed. At the clinic, she was diagnosed with ovarian cancer and her ovaries had to be removed. Before cancer surgery, she was offered a cycle of IVF treatment. During the consultation, she asked about egg freezing, but the clinic advised that it had a low success rate and was not available at the clinic, so she was recommended to consider embryo freezing. The clinic also informed she and Johnston that under the UK's Human Fertilisation and Embryology Act 1990, either party could withdraw consent at any point up until the embryos were transferred to the uterus. At that time, Johnston assured her that they would not split up and he was willing to be the father. With that assurance, they signed the consent forms. Evans then underwent the egg retrieval procedure. 11 eggs were collected and 6 embryos were created and frozen. However, months later, the couple separated and Johnston wrote to the clinic to withdraw his consent for any future use of the embryos. Under the 1990 Act, this meant the embryos had to be destroyed. For Evans, those embryos represented her last chance to have a genetic child, so she acted quickly. She and her lawyer took the case to the UK courts, but they all ruled against her. After exhausting domestic remedies, she appealed to the European Court of Human Rights under Articles 2, 8 and 14 of the European Convention on Human Rights. In the final appeal, the European Court of Human Rights was sitting as a grand chamber with 17 judges. The question presented to them was whether UK law, by requiring continuing consent from both genetic parents for embryo use, violated Evans' rights under Articles 2, 8 and 14 of the Convention. The short answer was no. The court held that UK law did not violate Evans' rights, but the court was divided. On Article 2, right to life, all judges agreed that there was no violation, but on Article 8, right to respect for private and family life, and on Article 14, prohibition of discrimination, the 17 judges ruled 13-4. 4 judges strongly dissented. We'll get to them. But first, let's check on why the majority ruled against Evans. Well, to begin with, the court looked at Evans' claim under Article 2. Article 2 says everyone's right to life shall be protected by law. Evans argued that UK law violated the embryo's right to life, but the court cited View against France. This case established that there is no European consensus on when life begins, so it is up to each state to decide when the right to life begins. Under UK law, embryos are not considered human and have no independent rights, and cannot claim or have anyone claim on their behalf a right to life. So the court unanimously found no breach of Article 2. Now let's move on to Article 8 and take a closer look at the arguments put forward by each side and see how the court reasoned. This article is a qualified right. It means that you have a right to live your private and family life, but it's not absolute. The state can intervene if its interference is lawful, necessary, and proportionate in order to protect others or the wider public interest. Under Evans' Article 8 claim, she argued that although IVF needs regulation, It was unfair to give one gamete provider an absolute veto. She said that the law was inflexible and failed to consider exceptional circumstances. She stressed that women bear far greater physical and emotional investment in IVF, and in her case, after surviving cancer, this was her last chance to have a genetic child, so her Article 8 rights deserved greater weight. Yet UK law placed her future entirely in Johnston's hands. She further argued that it was unfair that UK law allowed one party to destroy the embryos created by both. The court should balance the competing rights and consider exceptional circumstances. Whereas the UK government denied that was the case, they said that Johnston had never consented to Evans using the embryos alone. They argued that this was not simply a conflict between two private persons. The legislation in question also served wider public interests in upholding the principle of the primacy of consent, the interests of any future child, promoting legal clarity and certainty, and equality between gamete providers. They further argued that IVF regulation involved deeply sensitive moral and ethical issues, and that there was no European consensus on this matter, so the UK deserved a wide margin of appreciation. In other words, freedom to decide how to regulate. So both sides, the applicant Evans and the respondent UK government, were asking the court to rule in their favour. Okay, now you may wonder, what did the court say? The court primarily focused on three things. What right are we really talking about here? Is it a positive obligation case or a negative one? And how much freedom the UK should have in regulating IVF? And all this came down to one central question. Did UK law strike a fair balance between competing public and private interests? Let's break them down. First, the court identified that the right at issue was the right to respect for the decision to become a parent in the genetic sense, and it fell within the scope of Article 8. But this was not the case with only one side. It involved two private persons conflicting Article 8 rights. That is, Evans wanted to be a parent, but Johnston didn't. On top of that, the court said it also had to consider wider public interests. Next, in this case, should the state obligation under Article 8 be viewed as positive or negative? The answer to this question is important because it would determine the court's route of reasoning. Here's a brief theoretical background. In legal terms, positive obligation means the state must take reasonable proactive steps to protect convention rights, like setting up a proper legal framework. Negative obligation means it must not interfere with these rights. In the current case, the court viewed the obligation of the state under Article 8 as a positive one. Then the question became, did the 1990 Act strike a fair balance between public and private interests? The court said yes, because the 1990 Act emerged from a very detailed examination of the social, ethical, and legal issues surrounding human fertilization and embryology. It provides clarity and certainty, which is of utmost importance for society at large. Upholding the primacy of consent in law is important for the future of all patients receiving treatment. Allowing exceptions would risk opening the floodgates to further disputes. The court admitted that this rule may lead to harsh outcomes in individual cases, but this alone did not make it incompatible with Article 8. Finally, the court granted the UK a wide margin of appreciation on the basis that there was no clear European consensus on how IVF should be regulated, whose rights should prevail in disputes like this, and whether women's greater physical and emotional burden in IVF should matter legally. The court decided to step back and allow member states to decide what's best for them. So it concluded that Evans' right to have a genetic child did not outweigh Johnston's right not to be the father, and it gave no special legal weight to women's greater burden in IVF. Given the lack of European consensus and the fact that the domestic rules were clear and Evans was informed and the balance was fair, the court found no violation of Article 8. After Article 8, the court moved on to Article 14, Prohibition of Discrimination. This article ensures the rights in the Convention are enjoyed without discrimination based on factors like sex, race, or color, and etc. Evans claimed discrimination on sex and disability grounds, arguing that women who conceive naturally have exclusive control over their embryos, but women like herself could only get pregnant while IVF was subject to the control of the sperm donor or the sperm provider, so their ability to exercise Article 8 rights was unfairly limited. The court dismissed Evans' claim, reasoning that Article 14 protects only against discrimination in relation to existing convention rights. Since it found no violation of Article 8, there was no basis for Article 14 violation either. The court held that UK law struck a fair balance between competing interests. The destruction of the embryos, though tragic for Evans, did not amount to a violation of the convention. Evans lost this case, and the embryos were all destroyed after this judgment. She lost her last chance to have a genetic child. However, 4 judges dissented from the court's judgment on Articles 8 and 14. They considered that Evans should be allowed to use the frozen embryos. They issued a joint dissenting opinion where they adopted a more context-sensitive approach to the application of law, and with a particular focus on Evans' position as a woman. In their view, the UK's consent rule meant a woman in Evans' position could never secure her ability to have a genetic child, thereby frustrating the very purpose of reproductive medicine and the Convention's protection for human dignity and autonomy. On Article 8, the disagreement began with how to frame the case. The majority framed it as a positive obligation case, focused on fair balance, but the dissent said, no, this was an interference with Evans' right to become a genetic parent, a negative obligation case. So the real question under Article 8 was whether the interference was necessary and proportionate. Their answer was no. They accepted that the clear and bright line consent rule served legitimate aims, but they found it too rigid and failed to consider that this was Evans' last chance. The absolute nature of the law made it impossible to really balance the interests, but undermined her reproductive autonomy, because the law did not just limit her choice, it completely removed it. By contrast, Johnston could still have genetic kids in the future. This, according to the dissent, was not a fair balance. A disproportionate burden was imposed on Evans. The dissent also looked at the broader picture. UK law meant a woman in Evans' position could never secure a genetic child because the sperm provider could always veto it. And this raised real concerns for the dissenting judges, given the historical and social constraints on women's reproductive autonomy. The majority's judgment actually reinforced the problem. They narrowly focused on formal consent. Key factors like Evans' medical condition, Johnston's assurance, and her position as a woman were given too little weight. Evans acted in good faith and believed that Johnston would honor his commitment. Otherwise, she could have explored other options to ensure her chances of having a genetic child. Here the dissent took the view that once the embryos were created, Johnston's control over his gametes was no longer absolute. If not, assisted conception could end up giving women less protection than natural conception. Finally, the dissent rejected the majority's margin of appreciation reasoning, criticizing it as too simple and mechanical. In their view, this doctrine is not a free pass. It should not prevent the court from exercising its control. Rather, it requires genuine scrutiny to establish whether UK law struck a fair balance. The dissent concluded that it did not. Here the law imposed a disproportionate burden on Evans, and it cannot be necessary, even if the aims are legitimate. Thus, Article 8 was violated. Now on Article 14, Prohibition of Discrimination. The dissent made a clear point. Men and women are not in the same position when it comes to reproduction. Women bear a much heavier physical and emotional burden. Their biological and reproductive differences mean their situations are fundamentally different from men, and the impact of the decisions like this falls much more heavily on women. Because of that, the law must adopt a women-centered approach in reproductive matters, particularly in reproductive medicine. Failing to do so can amount to discrimination, and this was specified in CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. The Strasbourg case law also established that treating different situations the same can be discriminatory. In light of this, the dissent found that the majority's formal and contractual approach to consent failed to deliver substantive equality. The outcome was clear. Evans lost her last chance to have a genetic child. Johnston lost nothing comparable. The law, which allowed either party to withdraw consent before implantation, looked equal on paper, but in reality it produced unfair outcomes, and this was discrimination. In the end, the dissent concluded that UK law, although served legitimate aims, failed to consider Evans' exceptional circumstances. It was neither necessary nor proportionate, and failed to strike the right balance. Hence, it violated Articles 8 and 14. For many women facing cancer treatment, infertility is a real risk, and decisions must be made quickly and under great pressure. Egg freezing gives these women greater control, but the live birth rate from frozen eggs is relatively low. Creating embryos offers a higher success rate, but also creates legal risks. The case of Evans tells us that reproductive autonomy is not absolute. It operates within a framework of mutual and ongoing consent, and sometimes that framework produces legally sound but personally devastating outcomes. Thank you so much for watching. Take care of yourself, and I'll see you in the next video. And sit. Yes.